for all. We believe that the working condition of the host country should apply for all workers, regardless of where they are from. And I think we have all seen the terrible scandals over the summer. We have had numerous of terrible treatment of posted workers in especially agriculture and slaughterhouses. I can say sitting here in Copenhagen that as late as yesterday, the big news in Denmark was that a huge number of our Polish colleagues working in the construction sector in Copenhagen have been affected by the coronavirus due to the measures that were not sufficient enough to protect them. So this I think highlights the current problem of having bad conditions for workers being posted to other countries during the pandemic. But unfortunately, the problem of social dumping and a race to the bottom for workers is unfortunately not new. The problem is created by the internal market that has put the rights of companies above the rights of workers. And the posting directive have become a problem in itself. And that happened primarily due to the Laval ruling of the European Court of Justice against the Swedish trade unions and their attempt to secure equal conditions for their Lithuanian colleagues. This was not allowed by the European Court of Justice. And since then, we have seen that the posting directive have become what you could call a maximum directive instead of an absolute minimum. And the revised directive have not fundamentally changed the problems that we see to be continuing with exploitation, with discrimination, and with underpayment. So that is why, to finalize, that this debate is so important. And as Marina has already said, there will be some very good and excellent speakers with us today. So I hope you will get an overview both from what's happening on the ground, what is happening from the trade union perspective, and also what is happening from a European Union and Parliament perspective from my good colleagues in the left group. So I will once again welcome all of you, and hopefully you will have good questions and comments for all of you participating. So thank you for spending time with us today.
Well, thank you very much, Nikolai. Thank you for this amazing introduction. So let's start indeed with the very first panel. We have 4 speakers. First of all, we'll have Christian. Christian is a posted worker. Well, he used to be posted. He has been posted for years throughout Europe, and he'll talk about his reality on the ground, what he lived in different countries throughout Europe. Afterwards, we'll have 2 interventions from trade unions. First of all, we'll have Manuela Parascivioni, who comes from the Italian trade union Filia Sigil, from the building sector, and this is an industry which is affected by posted work. She will explain what's happening with posted workers in Italy, and then we will have an intervention from Simon Reder Momsen, who comes from the Danish trade union 3F, and he will talk about his views and about what's happening in Denmark. And finally, we will have Rui Pereira, who is a labor inspector in Portugal, and he will talk about controlling posted work, what's happening, what's at stake, and so on. He'll talk about what's happening more generally in Europe. So let's start with Christian. Christian, we are delighted to have you here today. More often than not, it is difficult to have posted workers who are ready to talk about what they lived. And we are happy to have the opportunity to hear you because you have been posted in Germany, in France, in Italy, in Spain. And it was very important for us, well, to start this debate with hearing you and hearing this experience you have as a posted worker in Europe. So, Christian, if you hear me, could you please, well, talk about what you went through as posted worker in the different countries where you were posted over the last 10 or 20 years?
Hello, and thank you very much for this invitation. I would like to thank especially to Marina and Elena, who helped me a lot throughout my experience in different countries where I've been posted: Spain, Italy, Germany, France, Belgium. In France, I was posted in 2013. I received a contract in Dunkirk as a mechanic, and the contract lasted until 2015 or 2016, I'm not sure. However, in 2014, I had a work-related incident, and the recruiting companies in Romania, so companies recruiting people, telling them they have a job, but when they get at that place, they realize they have to do something else, and their rights aren't respected. So that's what happened to me. I had a work-related incident in Dunkirk, in France. The recruiting company tried to get rid of me because I broke my leg there on the site. However, Marina helped me, and I'm very grateful both to her and to Elena. I contacted the labor authority in France, and I managed to recover some of the sums due to me. However, even up to this point, I don't know what is the state of play with my file regarding the work-related accident. I have been waiting for an answer from the labor authority in France. I haven't received any answer. In any case, I went on my way. I healed from my wound. I went back to Romania, and then I tried to go back to the West, hoping to find a better company, a better job opportunity. And then I went to Belgium, and I worked there as a driver, 14 to 15 hours on the truck, without taking into account the tachograph, the rules on the resting time, and so on. The Belgian company, Accede, again, tried to get rid of me. They didn't want to pay what I was due, and all the other benefits. And then what did I do? I went back to Marina. Marina contacted Elena, and I received help. Marina came to Belgium, contacted the Belgian authorities, labor authorities. I managed to recover some of the money that was due to me, but not everything. And now, after the pandemics and all that, I have no other news or answer regarding the overtime I worked, the weekends when I worked. It was a form of modern slavery. Unless, had there not been for the trade union and the labor authorities and my courage to act like a whistleblower about what these companies are doing. They are recruiting workers, they are promising a good pay. They are telling them, yes, you are going to be paid for your overtime. But once you get there, you realize nothing of that is respected. You sign a contract of 3 months, and they do that in order to circumvent some rules and to pay all the taxes and all that. However, they're trying to not to pay everything that is due to me. In France, for example, I didn't have a medical insurance either. Only after I had the incident did I realize that I didn't have a medical insurance. So I left Belgium, and then I went to Germany with another company. It was a subcontracting situation from a Polish firm. And then when I requested my work contract, they refused to give it to me. And they didn't allow me to work there anymore because they were irked about my asking so many questions and wanting so many answers. So after all these experience, and despite them, I still tried to find a job in the West, but I lost my confidence in all those recruiting companies in Romania because they're telling you one thing, but then we realize they don't respect the rules, they don't pay what they have to. I was very lucky to have known Marina, but there are many fellow Romanians in a similar situations refusing to say it as it is because they're afraid. I worked with many Romanians, and even when Marina came to Belgium and contacted the labor authorities there, I tried to contact other colleagues to ask them to tell it how it is, but they were afraid. They were threatened with different things because their papers weren't in order. But the recruiting company refused to pay all the contributions. And after years and years and years, those people ended up having to pay arreared contributions and taxes. They were obliged to do so because the recruiting company hadn't paid everything that was due. So once again, I was very lucky to have contacted Marina and the trade union and everything else, everyone else who got involved. It would have been very difficult for me if I hadn't known Marina. I don't think I would have made it on my own in Belgium to, to know who to contact, the labor authorities and other authorities. I was only able to do that with her help. And then when I got to Belgium, other colleagues asked me to provide the details about the labor authority in Belgium, and they also fought for the due revenue that they had to recover. It's hard to know how all the system works. However, once I had this experience, other people tried to get the contact details from me to contact the relevant authorities, and they managed to solve some of their issues. Now, I received recently a notification from the Belgian labor authorities that so I was supposedly paid 1,800 euros from a Belgian firm, which wasn't exactly true because yes, indeed, I received some money, but it was 500 euros less than what I was due. So then I contacted the Belgian authorities. I sent the proof of payment, and I asked, how come the firm said they paid 1,800 euros and I only received 1,300, so 500 euros less. I tried to contact the lady from the Belgian labor authorities, but I received no further answer. Now I am in Romania, same old story in Romania as well. The pay is absolute misery. It's 400, 450 euros, considering my 40 years experience as a mechanic. So that's how things are. I'm afraid to look any further because I don't trust any recruiting firms in order to find a job, to be able to pay the taxes, to take care of my family and all that. I'm here at my work, but I don't actually have anything to do because of the pandemic situation. The salary again is a misery, and also because of the pandemic, but I have to be present at work. I have to come. Otherwise, well, my contract can be annulled. What else can I tell you? I'm happy that there is a struggle going on. And I'm happy for all Marina's and Elena's involvement. And I'm really happy that there is a fight for the rights of the workers. But unless workers have the courage to contact the trade union, to contact the labor authorities when they see something is wrong, I'm not not sure how the labor authorities can carry out checks if they don't have reports on things going wrong, if they are not alerted about such situations. So how can they carry out their checks if uh, they, uh, these things aren't reported? But then the workers are always under threat, because the moment someone is trying to tell the truth, all those bosses and employers and others are trying to get rid of it, that worker. However, I refuse to back down. I refuse to sign any paper in which I would say that it wasn't a work-related accident, but something else. And because I refused to do that, to back down, they tried to get rid of me. And then all the recruiting firms in Romania, despite my qualification and experience, I was able to specialize in any mechanic related work. But they didn't like that my attitude and the fact that I was ready to contact the trade union to claim my rights and so on. So that is the situation. After a while, they refused to recruit me anymore, despite the fact that I was willing to test, to prove my experience. However, the commission for recruiting, so the recruiting fees in Romania are quite high. So a Romanian worker wanting to work abroad is recruited by a company and receives 5 euros per hour. That's what they claim they can pay. So this is widespread in all work contracts. These are widespread practices, and the real number of hours per day is 10 to 15. So, and the pay per hour is 5 euros. And people work much more than 8 hours in order to gain a small amount of money. And they try to earn at least 60 euros per day. But once they work every day, 12 hours, 14 hours, they are not as productive as in the first week of employment. And that's when security fails and work incidents happen, because people feel compelled to go to work, even if they're sick, even if they're exhausted, and they don't have the same energy to work. They don't have the same productivity level. Their attention level decreases, and that's how accident happens. Accidents that companies refuse to acknowledge because of course they would be subject to huge fines, and that's why they're trying to hide away work-related incidents. I haven't heard anyone talking about fatalities at work, because maybe because of that situation. Thank you very much. And I'm happy once again to be here.
Thank you very much, Christian, for your testimony. I don't know whether you all understood properly, but through his testimony, he went from Romania to be posted in Germany, Belgium, and France with non-Romanian agreements, contracts. So he had, for example, Polish working contracts, also Slovakian working contracts. He never went there, but he was posted from those countries to France, Belgium, and Germany. So it is quite a terrifying situation, actually. And fortunately, some workers are ready to fight, to mobilize in order to make their voices heard in a very complicated system. As a transition, as Christian explained, through trade unions in the different countries ready to support the workers when they are struggling. We will now give the floor to Manuela, who is an Italian trade unionist defending workers such as Christian who are struggling when they are posted, to show what the trade union can do and also the different problems they can have while doing posted work nowadays. I now give the floor to Manuela so that she can explain the trade union perspective she has with the posted worker.
Good morning, everyone. Thank you for the invitation to take part in this webinar. I'm very happy to see old friends. Let's call them old friends. So my name is Manuela Paraschivoi. I work for Finlea CGL Lazio for more than 10 years. So every day I meet on the territory in Rome and the region of Lazio. Some workers coming from all over the countries, and so EU countries and non-EU countries, they come to us to complain because they have not been paid, or they tell us about fraudulent contracts and all problems concerning work. So the outcome of my participation, which dates back 4 years ago, it is a European project which was called Reader. So I had the opportunity to personally participate in several meetings, and we discussed 6 different cases, and 3 of these cases had more than 5 workers. So I defended them, and there were 3 other cases with 2 or 3 posted workers who contacted me. They contacted me also thanks to the network which is established among workers, and also in the case which I followed together with Christian, because slowly other workers were informed about what we were doing. And so I was contacted by telephone. They didn't know me, but somehow what you do is always appreciated. And so all these workers contacted me to ask for help. And of course, all these cases were dealt with and solved not only by me, but also thanks to the collaboration among the different trade unions in Europe, and thanks to the support from the inspectors at European level, with whom we had the opportunity to collaborate and to meet, because it was important to know how the world of the inspectors works, because everything is very new to us. So over the last 4 years, the trade union relations strengthened, but in my opinion, the collaboration must be increased in order to face in a more effective way all the criticalities and issues stemming from fraudulent detachments of workers, and because many remunerations are not paid, or there is social dumping, or there are problems concerning safety at work, and also in terms of social security. There are many issues. So I believe that it is necessary to start a collaboration among trade unions, and this collaboration has to be more effective and stronger, because only through this strong collaboration we can better know the European regulations and the different practices which are followed by the different countries. And so only through this collaboration we can get all information necessary to fight against fraudulent posting of workers. And for sure there are many difficulties, especially linked to the language barriers, because it is difficult to deal with languages that are less known, such as Polish or Bulgarian, which are very difficult languages to understand. But in general, there is this barrier, the language barrier. And there are also huge differences among the different regulations and legal systems of the countries, but this will never prevent us from tackling all these issues. A concrete case which I worked on and which I got very important results is a Swedish case. I called it Swedish case because the construction yard, was located in Sweden, and it was an irregular posting of workers. 8 workers from Romania, so more or less 8. I'm not sure how many of them were there because just one of them contacted me, but it was almost 8 or 10 workers. So he had been hired by a Polish company with a Polish contract. The company didn't exist. So the headquarters, the legal office didn't exist. So they were posted to Sweden, but they never went to Poland. And so they went to work for an Italian company in Sweden. So these workers didn't receive the last payments, and they stopped the work activities because the construction works ended, and so they went back to Romania. And also that time they contacted me by phone through the information I received from them through emails and different types of information. And thanks to the assessment and checks performed by this company, we activated the solidarity responsibility, which exists in Italy, well, not only in Italy, which belongs to the company, and so the ownership of the Swedish construction yard. And this was done also thanks to the collaboration with the Swedish trade union. So thanks to the collaboration with the Swedish trade union, that I'd like to thank once again, we managed to organize a meeting with the persons in charge of the works, so the Italian company that had given the contract to the workers. And so, after a very long negotiation, we were able to obtain the monthly payment from the Italian company. And so, the Swedish trade union called the Swedish contractor and the Italian contractor. And so there was this negotiation, and they informed about this complaint. So unfortunately, this is, how can I say, this is a case which had good results, achieved good results, thanks to the collaboration with the Swedish trade union and our expertise. But unfortunately, we do not have time to tell all the issues that we had to tackle because I was just summarizing what happened, but it is very, very difficult to get all information. It is not always so easy. It is difficult to understand who are the persons responsible, especially when the construction yard has ended and we didn't get the information at the right time. So these are all issues such as the speed through which we have to work. So there are some because of the deadlines or the accidents at work. So all these issues need to be tackled in a very timely manner. So there is a lot of pressure on workers who want to report these exploitations. There are situations of exploitation which we didn't manage to identify and to detect also in Italy, because unfortunately there are many cases in Italy, but we don't manage to find, to detect all of them all the time. So there are not many inspectors. The number of inspectors is limited, and inspections have to be immediate and quick because construction yards are open and then close. We cannot start inspections after 6 months or 8 months, because maybe the construction yard has already been ended and closed. And this is something which happened. So before we understood everything, the whole situation, etc., the workers had already left to Germany. So this was another case we worked on. So there are many, many, many issues that we have to tackle every day. So we believe that there must be a law that can support us. There is also the problem concerning the unionization of workers, because not all trade unions, if you're not a member of an associate of the trade unions, they cannot help you. So these are there are many, many problems. Maybe today we do not have time to discuss all these issues. Anyway, CGL always tries to help and to help workers, especially the Filea trade union, because we try to protect individuals, so even just one worker or two workers, and also many workers. So sometimes workers must be supported, and so we try to do our best to support all workers. So that's all. Maybe I spoke too much. I thank you, and I'm very interested in listening to your contributions, because these meetings are always very fruitful. Thank you.
Merci beaucoup, Manuela.
Well, thank you to you, Manuela. Thank you for all this information. It is very interesting to hear how, as a trade unionist, indeed you can be facing issues related to Romanian workers working in Sweden for a Polish company, who then are supposed to be paid by an Italian company, which then may be held by Egyptian owners. So sometimes it is very, very tricky, and sometimes one cannot simply imagine that these structures are like that, and that posted work can lead to so many challenges, even for a trade union. Uh, Challenges which sometimes make it impossible to find owners or people to whom you could demand the wages which are due to workers. But to continue talking about trade unions, and let's move on to Simon. Simon, who obviously has a trade unionist view, a view from Denmark, and uh, over to you, Simon.
Thank you very much, and thank you for inviting me to this very interesting conference. I'm representing 3F. We are the United Federation of Workers in Denmark, organizing workers within manufacturing, construction, transport, services, hotels, restaurants, agriculture, and representing both public and private sector workers. I'll talk briefly about the challenges from a Danish point of view on posted workers, also a bit more general on migrant workers in Denmark, how we deal with the challenges, and then end briefly by giving some proposals on how we may go on from here. So first, on the status, there are approximately 140,000 full-time employed workers from EU, EEA countries in Denmark, and the numbers are increasing. Most are coming from Poland and from Romania. And I'm mentioning initially this number because the challenges are broader than just posting, at least in Denmark. But when we're talking about posted workers, there are approximately 29,000 posted workers annually in Denmark. 55% are coming from either Germany or Poland. And then we have an additional about 15% coming from France and Italy. And then, of course, the rest coming from other European countries. And initially, it's good that we're getting workers into Denmark. But of course, the challenge is that we need to ensure there's equal pay for the equal work at the same place, and that is a very fine principle, well established, but also a principle, unfortunately, that often only exists on paper, as the previous presenters also gave some very good um, examples on. Also in Denmark, the reality for many workers coming from other European countries is a reality of threats, of blacklistings, violence, and repaying salaries to money collectors. So just supporting what has been said already, a lot of fraud going on in this sector, unfortunately. When it comes to exploitation of workers, some employers seems to have no limits in their creativity, and that is no matter whether the worker is a posted worker, seasonal worker, is a false self-employed, or whatever prefix we put on it. We know what we're talking about in 3F. 9 out of 10 workers in Denmark from Eastern Europe are employed within professions where we are organizing the workers. Just for one example, within our green sector, half of the workforce is non-Danish, and we have colleagues, it's not unusual, who work 48 hours for half the wage of their Danish colleagues. They're not posted within the green sector. They're coming through temporary work agencies, seasonal workers, subcontracting of subcontractors, and they do all they can to avoid respecting rules on the Danish labor market. And we see that this is becoming more and more common, and it's systemic. It's very organized. However, I'll try and focus on the challenges we have within posted workers from now on. Here, around 70% of the posted workers are within construction, so that is also what will be the focus here. And we face challenges both with regards to lacking collective bargaining coverage of posted workers. These statistics are, for obvious reasons, difficult to have, but we have some own older estimates that 34% of the work done by posted construction companies in Denmark are covered by collective bargaining agreements. And just to compare, 88% of construction work in general done by Danish workers are covered by collective agreements. And of course, in this, we find some of the very grave examples of exploitation of posted workers. But we're also facing challenges when we have companies signing collective bargaining agreements. The construction group alone is taking around 500 cases annually to the labor court for breaches on collective bargaining agreements, and they win them. So it's not a question of it's a very clear trend, and it's very clear breaches, and we win, as I said, but it's also fairly evident to state that if Danish workers were breaching collective agreements, or Danish companies were breaching collective bargaining agreements at the same rate as posting companies, the entire Danish model would collapse, and we simply wouldn't be able to do legal processings of all of these breaches. And finally, even when we do have foreign contractors adhering to collective bargaining agreements, they are only obliged to pay minimum wages within the Danish construction sector. And here it gets a bit technical, but but what is common in Denmark is that you pay normal wages. So the minimum wage is an absolute floor that has been put into the agreements in order to prevent working poverty in Denmark. But in general, Danish workers are usually working, have a salary that is at least 50% above the minimum wages set out in the collective bargaining agreements. Let me also be clear on this. This is, when we are talking about these challenges, we're not talking about shady work done in a basement in the weekends, far away from law and order. We see the biggest challenges, many of our biggest challenges originate from the biggest and most prestigious construction works in Denmark. I'll mention just a few. Currently, the pharmaceutical giant Ferring, which is owned by a Swedish billionaire, Fredrik Poulsen, he has, by the way, a personal net worth of about 4 billion euros. They are building a new domicile in Copenhagen. And as has become the new normal in Denmark, Italian contractors won this construction task. And on September 10th, Edil Planet from Verona set a new Danish record when the labor court sentenced them to paying a fee of 27 million kroner, which is approximately 4 million euros, for systematic wage dumping of 150 foreign construction workers, which is the single biggest fee in a social dumping case in Denmark. This is a construction work worth of 1.1 billion Danish kroner. And already now it's still ongoing, and already now there has been handed out fees for social dumping worth of 36.5 million Danish kroner. So it's pretty high percentage of the overall budget, which is being where we can prove that there has been conducted social dumping. Unfortunately, the record may not stand for long. We have other very big cases underway in the labor court with social dumping. The Ferring case is not something unique. There's an ongoing construction of the third largest Danish bridge. This was also won by an Italian contractor because they could offer lower wages. There was a Danish bidder. That bidder was assessed to be able to construct the highest quality bridge, but it was also 400 million kroner more expensive, largely due to salaries. On this bridge project, non-Danish workers are paid between 7 and 11 euros less per hour than their Danish colleagues, because of what I explained before about the distinction between minimum wages and normal wages. So history repeats itself on all of the big construction projects, which pose evident challenges for the Danish labor market, the Danish workers, and also our foreign colleagues who are being exploited. We are doing what we can to curb these challenges through negotiations, through our conflict weapon, and also by taking contractors to the court. However, as we see with the Italian contractor, Solesi, we may not always be able to recover the fees. Solesi, they were sentenced to pay 14 million euros in 2017 to 130 posted underpaid workers who were working on a construction site in Denmark. They refused to pay. They left Denmark. And now 3F is engaged in a protracted legal battle in Italy that will probably last years to come, and before we may or may not get the money, and we probably will end up paying a higher bill to lawyers than the actual original fee that they were sentenced to pay for this social dumping. So the challenges we're facing are plenty. We are facing a systemic problem and some scrupulous opponents, and sometimes we have very little help from from the EU. We have a mandatory register on foreign service providers, which is a very effective tool in Denmark towards exposing social dumping and false self-employed. 50% of the registered in this register is one-man companies, and evidently a lot of these people are false self-employed. However, instead of diversifying these good experiences with this register, the European Commission has decided to instigate a treaty infringement case on Denmark, forcing the Danish government to present a revised and less extensive register. So this is definitely not helping us. This is definitely not helping the work to create or the efforts to create decent work in Denmark and in Europe. We're doing what we can, and we still have a strong labor market model in Denmark. And we can do many things as social partners, and we do so. Our members display a high degree of solidarity. We had this spring triannual collective bargaining negotiations for the entire private sector in Denmark. And here the construction group, my colleagues in construction, were willing to scrap all other demands in order to ensure a significant increase in the absolute minimum pay, which is basically, as I said, only used to pay foreign colleagues. Unfortunately, that was prevented by the sudden COVID crisis. That meant we had to settle with a less ambitious result in the collective bargaining. However, as this conference also shows, this is not a Danish problem. Christian's story shows it very clear. So we need more European solutions. And this is also why we have an office here in Brussels as one of the very few national trade unions in Europe. We need long-term solutions that create upward social cohesion that will eradicate the incentive for working on social dumping standards. We need EU funds that capacity build trade unions and strengthen collective bargaining models. And then in the shorter term, we need better legislation, better implementation, and better enforcement. That is why we need a social progress protocol, so that workers get workers' rights have the same priority as the four freedoms, and we have full flexibility as trade unions to defend these hard-won wage and working standards. And in order to have more enforcement, we propose a European Social Security number combined with a personal labor card, which could be a transparent and effective tool towards helping ensure that workers work under decent and local conditions, and that companies comply with their obligations, so that we fulfill this principle of equal pay for equal work in the same place for all European workers. We know from national and local experiences that such a personal labor card is highly efficient. We also propose a revised public procurement directive to implement stronger social clauses and limiting the use of some subcontractors, temporary workers, and ruling out fraudulent social dumping companies. Yeah, I think it's, I used my time.
Merci beaucoup.
Thank you very
Simon.
much. Thank you very much, Simon. Of course, we could develop a bit more in the Q&A if you like, of course. But thank you for your comments. It was really interesting. We have quite the same conclusion, at least, after the previous panelists' words. That was interesting to hear that you could focus your comments on the judiciary effort. How can we prosecute companies? Can we make sure that they are convicted? And this leads us to the last panelist. In order to convict a company, we will have to work with the work inspectorate and to carry out investigations to also observe infractions, violations of the working conditions. So this leads us to Rui. Thank you very much for being with us today. Could you please tell us from your perspective in Portugal as a work inspector, what are the main stakes around posting work today? Thank you. It's a pleasure for me to be here today and to talk about posting. It is a very interesting topic for us um, in Portugal.
I will try to put the PowerPoint. I think it's easy to me. It's my guideline, and I think it's better for translation. We'll see if it's okay.
Oui, on voit bien.
Ok. Então vou agora falar em português.
So now I'm going to speak Portuguese, taking advantage of the fact that we have interpretation, which I thank you for. I can't speak on my mother language every day. So thank you again for the invitation. It is a pleasure to be part of our European Parliament. So I'll try to speak slowly. And I know in 10 minutes, that's not an easy task. So I won't be able to say everything that I would like to, but I will try my best. So I'm going to try and touch 4 points in a summarized way. They are here mentioned, and I'm just going to jump right in. When we talk about workers' mobility, there is a quote in Portuguese that says, if something is born gauche, it will never be made right. But what we mean is the question of mobility and workers posting was never an easy one. It has always been difficult. And the first directive on that subject took a long time. It was something that wasn't born perfect. And it is very difficult to change it once it's born like that. We must remember that the first decision on this community directive was with a Portuguese company in the construction sector in France. The relationships between France and Portugal were very long ones. And I think since 1997, we had posted workers in France. And the first decision from the Justice Course of the European Union was about that project. It's been a long time since 30 years. This first decision was from the 90s. Workers were already there. So this has more than 30 years now. So what were the developments in the past 30 years, if there were any? Because sometimes I doubt there were. The directive 96/71 was a compromising solution, which often happens in the European Union, and that's a good thing. But on the other hand, there are complex issues, ambiguity, and such as it happens, people have distinctive opinions and points of view, and that doesn't help those that have to control or manage it. Not only those who have to manage, but also the companies, the workers. So it is a very complex problem, really, from the beginning. What is a posted worker? And it's good to remind ourselves, because not everybody knows the subject. A posted worker is a worker that goes from one country to a host country, a third country, which is a destination country, in order to work. The labor agency and the work is limited. The workers are hired temporarily. They go for a certain amount of time and not ad aeternum, using a good Latin. And there was a case with Marina and Manuela, and hello, greetings to you all. There was a case where a Portuguese worker had been in France for 11 years. And of course, this is not why we created the posting work directive, but it is a reality that we see around. In order to provide a service, a company under the umbrella of another company will then request posted workers, and it can be within a certain economic group or using the help of a work agency, which we heard here today about. These workers that go from one country to another, they are still working for the company from the origin country, and they're working under the legislation of the origin country on the majority of cases. So in practice, the legislation comes from the country of origin. But as soon as the worker goes to another country, which is not his, there are a certain number of rules that generically we call a hard core of rules that should be respected in the destination country, in the host country. This is something that we could discuss on several webinars, from the basic remuneration to other subjects, which are still problems on the posting of workers. Of course, remuneration is not the only problem, but it's one of the main ones. Thank God that behind the labor legislation, there is a principle of law that is very important, which is the application of the regime that is the most favorable to workers. And this principle is still the basis of labor law in the European Union. However, there is a problem that I'd like to emphasize from now, and that to me at this point is one of the main problems that we should try and resolve, because while it's not solved, we won't be able to progress. And it has to do with the workers and the posting directive, but we have a social security regulation related to posted workers that is not exactly the same as the directive, and that brings problems. The objectives behind the posting directive are not the same that are behind the rules of social security, and that will bring different rights to the workers in different countries. So while we have that confusion, while the directive is more focused on labor and social security doesn't focus on posted workers, there will always be a problem. It can be very well explained by this chart. It is in a publishing from Eurofound, and it shows exactly the difference between what is under the directive framework and what is under the social security framework. So to me, that is one of the main problems at this point, and I think this should be resolved first. We also have an attached problem, which is the migrant workers, which is a different problem, but sometimes they have touch points and associated problems. However, there are at least 3 or 4 routes that are here described, and that can be applied and enforced to both types of workers. But workers under a work contract which is not really a contract most often. These workers very often have no access to the contract, and when they do, the rules and difficulties are so many that it doesn't really interest them. They just want to work and make money. So they don't really read the contract. They only read this contract when they need help. And that is quite often the case. So these are some of the difficulties, and I'm touching management and inspection issues here. I'm trying to generalize. I'm trying not to talk just about Portugal. Obviously, all of these problems that are applied to Portuguese inspection, they are kind of broad and they probably apply to most inspections and institutions that control posted workers. So the application of contracts sometimes are written in one language, and Manuela mentioned contracts that had workers from Romania working in Sweden. So there are linguistic barriers and problems to access information. You don't know what is in that contract. There is a normal and logical reaction about the legal framework. In some countries, in the original country, sometimes you know the legislation of your origin country, but when you are in country B or country C, there are differences in legislation, even though we are under the umbrella of the European Union and we are under the umbrella of the directive. But for sure, on the day-to-day and in the routine, there are several problems that are faced by posted workers, and they will definitely find difficulties on that way. Another problem, and that's connected to social security and its regulation, while we have different social standards within Europe, different social security standards, we will have problems in Europe, and companies will definitely take advantage of that. The difference between, for example, between the discounts you have to take from the payroll, whether in the origin country or the destination country. So based on those differences, that could be a problem that we will still face, and it's very difficult to manage. Obviously, we also try to take advantage of the qualifications and capacities of workers. Some workers have a lot higher abilities than the job they're doing in the destination country, and that is a very difficult problem to solve, because any organization that manages that sort of thing will find it difficult to identify those workers. Apart from that, I think these are unanimous in any institution of the European Union. The language barrier will always be a complex one. We might be able to speak a little bit of French, a little bit of Spanish, or a little bit of English, but we don't know how to speak Romanian or Bulgarian or Swedish, Italian. So the language will always be present. And through any inspection, it's difficult to have interpreters for all the nationalities that we will regularly find in the project sites. The legislation differences I talked about. Another problem that was touched upon by Simon is the collective convention problem, the collective bargaining is that's something really complex because there is no friendly solution, and the inspectors don't really know what remuneration those workers have to receive, it is very difficult for any inspector from the origin country to know how much they should make in the destination country, in the host country. If that's difficult for someone who's experienced, imagine how difficult it is for any company or any worker to understand what collective bargaining agreement applies to a certain worker. So there are so many different applications for everything, but we haven't found any apps that help a worker to understand what money they should be receiving on country A, B, or C. It is a brutal problem and it carries on being a difficulty for all parties. Manuela has already mentioned this as well. It's very easy for companies to move about. Last week or 15 days ago, one of the first pilot projects with the European Labour Authority had an action between France and Portugal. And it's very difficult to do anything with these companies. The French inspection applied a penalty of 270,000 euros onto a Portuguese temporary work agency. However, in a few days, the Portuguese company from 900 employees, then all of a sudden had only 2 employees and completely vanished. So it's a company that doesn't need a large organization. They have an office that is rented. The matrix is normally fictitious, and obviously we cannot charge that penalty. We cannot charge that fine because we won't be able to get anywhere because the company has already changed names, has vanished, and carries on doing the same thing under a different name. So this mobility is very difficult to deal with for any inspector, and it doesn't matter how much goodwill you have between inspectors and that it does exist. It's very difficult to control these companies, not only in your origin country, but also in the other countries. One of the cases that... Thank you. Thank you. Could you please conclude? 1 minute, please. 1 minute.
Alors, nós podemos concluir dizendo.
So we can conclude saying that how it doesn't matter how much, but the more information we have, the better. If we could share data between local authorities and host countries, that would be great. We need to have some sort of interchange in terms of taxes, in terms of common access to national services. Obviously, data protection here is something that we have to work with. And obviously, we need to review the community legislation on social security that's ongoing, but it would be an advancement in these issues. And that's it. Thank you very much. And I am available to any questions.
Merci beaucoup, Rui, et désolé de...
Thank you so much, Rue, and sorry for asking you to speed up. We would have liked to listen to you even more, but unfortunately, our time is limited. If we really want to proceed with those 2 panels in 2 hours, 30 minutes. So, you have talked about several things and have mentioned this legal framework, which will be discussed during the second panel, because yes, indeed, the system was maybe poorly thought at the beginning, and yes, we will need proposals to go forward, and we will listen to Marco and to his presentation of the study on labor mobility and equal treatment. But before that, a few questions. Obviously, we cannot take all questions because time is limited and it is important to give the floor to the second panel as well, panel which will tackle some questions which are in the chat. If I'm not mistaken, and my colleague Simon will be able to confirm or not I'm right, there were questions on the new directive, a question addressed to Simon from 3F. Do you think that the new directive, the 2018 directive, allowed to change things? This is the very first kind of question we got. And then we had another type of question on the European Labour Authority. Do you think this agency will help improve things on posted work? Especially since, Rui, you just talked about the very first inspections carried out by this authority. So we had these two questions on the 2018 directive and on this new agency. So Simon and Rui, maybe. Simon, to begin with, do you mind answering on this question about 2018 directive?
Yes, thank you very much. Well, we are happy with the revised directive from 2018. Denmark is unfortunately one of the countries where we have still not transposed it, and there is a discussion on how it should be done. And there are, especially because within construction, collective bargaining agreements are so special as they distinguish between the minimum wage and the normal wage. It makes it quite difficult to transpose the stipulations on wages. So there are improvements, but we are still struggling to see whether there will be any substantial improvements on the salary, the remuneration in the new directive, unfortunately. But it does provide some improvements. It doesn't solve the problem in Denmark, unfortunately.
Merci Simon.
Thank you very much, Simon. Rui, I see that there are questions on the investigation, the ongoing investigation in France and Portugal. Is it done under the European Labour Authority? Is it finished, or are there still procedures ongoing right now? These are questions of the participants.
Well, summarizing it to you, two things. One about the new directive. Portugal, for example, only this week, Parliament issued a law authorizing reviewing legislation. So we're really behind. We're supposed to do it by last July, if I'm not mistaken. We should have finished it by July, so we're about to start this transposition. So more 6 months ahead, certainly. That's how long it's going to last. So we're going to be behind. I agree with Simon. And I don't think this will solve the problem completely. No. In some cases, it might help. We'll still be facing the problem of wages, of social security. So it's a much more complex problem that will not be solved by the new directive and its enforcement. About the European Labour Authority, there have been many pilot experiences, two with the participation of Portugal, one involving Lithuania, Belgium, and Portugal about undeclared job, and one involving France with posted workers, posted temporary workers. These should be joint visits involving French and Portuguese inspectors, but this wasn't possible because of the pandemic. So they were canceled last minute because of the pandemic, as I said. So we and French inspectors decided to keep on going and do an intervention in Portugal. And we've been meeting and discussing the issue just like we are now, and with our our meetings. Well, they happen almost on a daily basis on Zoom, and we try to follow the evolution of the situation. This is one of the ways to go, but the difficulty is that companies are much faster and much more mobile than any inspection can follow. So it's a kind of a chase of a cat and mouse chase. So we're always a bit behind the mouse, and we can always get it. But it's a principle, and I defend. I think that we should have an ability to intervene very quickly, the European authority. But as long as we depend on countries' goodwill, I don't think those initiatives will be very successful because we always depend on their willingness to help, on each country's willingness to help. Of course, there are differences, but that's not ideal. Thank you.
Merci Rouille. Une question aussi.
Thank you. We have a question from Manuela as well. One of the participants was asking whether we could create networks. Indeed, you were mentioning networks, the different cooperations we could create from one country to another on those issues. Are we able to create networks so that we can investigate, so that we can support workers with temporary work recruitment agencies where there is a lot of fraud, actually? So how can we fight against non-declared work? So these are both questions for you. These are two questions for you, and you can give us an answer depending on your experience.
Yes, as Rui said, we could do it. It depends on what we want to do. I am very passionate about my job, and I would say that as a trade union, we should create networks of people among unions, among individuals. We should do whatever we can because, as Rui said, it is very, very difficult to act at a European level. So as trade unions, we should be close to workers, and I am totally open. I am here. You can ask for my contacts, and I know very well that I am of Romanian origin, but I've been living in Italy for quite a long time, and I know what unfair practices are. So I am at your disposal if you want to contact me. And I hope that this exchange will be fruitful, that we will be able to solve a lot of practical cases so that at a European level, this network can become stronger and stronger. Our RED network is a small one, but it can grow. We can do it at the level of the different European unions.
Merci Manuela.
Thank you, Manuela. If you are looking for information, the Red R, it is a European network for responsible posting. It is a network of 10 countries, work inspectorates and health organization in order to inform workers about their rights And those cooperations have been created now for years in order to consolidate the situation. Thank you to all the different panelists. Sorry if we were not able to raise all the different issues, but I hope that in the second panel we will be able to reply to some of your questions, and we will also have a Q&A session at the end of the second panel. Without further ado, let's start the second panel with, first of all, Marco Rocca, who is a PhD researcher at the Strasbourg University. He is going to present a study. That's why we have this conference today. It is a study about the difference we could bring to posted work. How can we make a difference? And these will be some replies to those questions. And then we will have the three MEPs, Mark Botenga from the PTB in Belgium, Leila Cheibi for the France Insoumise in France, and Nicolas Willumsen, you've seen in at the beginning of the meeting, and he will take the floor for Denmark. I will now give the floor to Marco. He can start his presentation on the study that was carried out within GUE on posted work. Thank you very much. Can you see my presentation? Yes. Thank you very much, Marina. Thank you for inviting me. It's really a pleasure for me to be here to talk about posted workers. It is a very interesting topic I've been dealing with for more than 10 years now, since I started my PhD research. As was explained, I will put forward some proposals that are contained in the study that I drafted. And before going to the proposals, maybe some introductory remarks. First of all, a general point to explain that those proposals do not aim at being the last resource possibilities. These are proposals that are based on a legal research, but some other solutions are possible. We could go beyond my proposals also. Then the legal analysis does not substitute the democratic debate and dialogue with the different social partners. So this is the introductory remark of my research background. The theoretical framework now. Those proposals are already at a high level, at the regulatory level of that phenomenon. Therefore, they will not give answers to practical issues in the implementation on the ground by the different stakeholders, such as social inspectorates. So no, this is about the applicable rules before talking about enforcement. Three theoretical points. First one, the free realization of services. This is the legal basis. That legal basis is of legal basis that is adopted that is adopted out of the different circumstances, and there was a veto in the past from the United Kingdom on new initiatives for social issue. The idea was then to have the posting directive to have qualified majority vote in order to avoid the veto of the United Kingdom. It was not out of a legal need. Second point, the free movement of workers. The aim of that free movement was to be the legal basis for all the movement for workers in Europe, covering then all the different workers circulating in order to give services. Third point, the real conflict. More often than not, the conflict, it is presented as a conflict between two groups of member states. Member states sending posted workers and member states welcoming them. hosting them. If we look at the reality, more often than not, these are practices carried out by companies that are based in the hosting countries of posted workers. They are using subcontractors and subcontractors chains in order to get less expensive work for and to circumvent also the local regulation. That issue of posted work is about sharing the profits of companies and workers. Then know the different proposals. These are 5 proposals. The first ones are on the working conditions and wages. There are 2 scenarios. The first one, it is a change of the posting directive 96/71. The first aspect would be to change the legal basis of that directive in order to include the free movement of workers and the social policy as a legal basis. It might seem quite theoretical, but actually it plays a key role. The legal basis plays a key role in the construction by the European Court of Justice of that directive. That interpretation today is of a tool that is facilitating the prestation of service, the providence of services. If the legal basis is the free movement of the workers, then the aim is to guarantee the treatment equality of all those workers. And then the work law becomes a legal basis. Second part of that proposal, it is also about the posting directive. It is to include posted workers from the first day in the regime that has been introduced for posting of more than 12 months, plus 6, potentially. Under that regime, all the working conditions under the law and under the CLAs will be applied to the posted workers. We use that regime from the very first day of the posting. No real issue about that. Everything that is mandatory is applicable from the very first day. Second aspect, the introduction of a principle of treatment equality for posted worker. There is then a prohibition of discrimination of posted workers in terms of working conditions and the use of CLAs, collective labor agreements. That will also allow to access collective bargaining in the hosting country. You might have heard about the Laval case and the difficulty to negotiate with a company posting workers. The equality of treatment and prohibition of discrimination would help avoid a new Laval case. Third proposal. It deals with the second scenario, where we would repeal that posting directive. It is interesting for 2 reasons, political and legal reasons. Political, why? Well, because posting was a very problematic regulation at the European level. It was really difficult as a discussion. And then we would start from scratch with a sounder, healthier regulation, more sustainable for the European Union. Second reason, this is a legal reason, that repeal and the new regulation I will show you later on would send a clearer message to the Court of Justice, saying that posting of worker needs to be considered as a part of the free movement of workers. In order to do so, posting, as I just explained, from the first day application, implementation of all the mandatory conditions and prohibition of discrimination, would be completely included under the regulation on the free movement of workers. By the way, if you wanted to have more information, in recital number 5, today and from 1968, can be applied to all mobile workers, including workers circulating to provide a service. So the idea was already there to have the free movement of workers to explain all the different mobilities for work. That proposal goes into that direction. Fourth proposal, two parts to talk about social security. As for social security, posted workers are still registered in the sending country. These raises many issues. For example, actually, posted worker is more interesting to companies because of the differences in the different countries with regards to social security. Actually, the aim is to reduce as much as possible the social contributions. My proposal aims at avoiding all the problems by legalizing all the social fees paid at the level of the hosting countries based on a global envelope. As we will not have a comparison element by element, but having an envelope with all the social security issues, giving a final amount to be paid. That amount should be paid before the posting of the worker, and it would substitute the pre-notification. I will come back on that issue a bit later. The amounts would be then paid back to the different states, the state of origin, except if the posting lasts for more than 24 months. In that case, the worker is completely registered in the hosting country in order to avoid transfer of resources. The hosting state, or rather, I'm mistaken, the origin state will benefit from the different fees and might, in fact, get a bit more fees. And the state of origin might then be free to do whatever it wishes with the different social fees in order to respect the national competence in terms of social security. The second part on those equal fees, contributions. Posted workers would be able to choose to be covered by the social security system of the hosting country for temporary risks arising during the posting, for example, an illness. Today, posted worker can be entitled to medical leave, and this creates a perverse effects. It can lead to different problems. Same goes for maternity, work accidents, and also for temporary unemployment for extraordinary events. By the way, the COVID-19 showed the importance of that because posted workers were sometimes blocked in the hosting country, and their workplace was closed because of the lockdown, and they were not able to get access to benefit from temporary unemployment because the employer did not pay contribution in the hosting country. That solution helps avoid those problems. I would like to underline, as I explained in the beginning, that it is not the only solution possible. While we prepared the study, we discussed about the possibility to contemplate the registration in the hosting country directly for posted worker. It could be truly an interesting solution. In the study, I explained that it was a bit more complicated than that, politically and legally speaking, while being interesting. If because links relationship with origin countries are quite low. We heard in the first panel that sometimes their contracts of posted workers are contracts from a third country. So they have no interest of being registered in a country they don't know, hence the interest of the hosting country. Then the follow-up and control, it is a bit more technical. First of all, the official national website. They should allow the online payment of social contributions. That was introduced in proposal number 4 by substituting the previous notification system. Today, in the negotiation of the reform for the coordination regulation, we have discussions about the previous notification. That tool would help simplify both instruments uh, because we would only have one notification system. Secondly, through that system, it would be possible to put at the disposal of the hosting country electronically a document, for example, with a QR code to get the information given by the employer, the duration of the posting, the wage, and so on and so forth. It would help social inspectorate to check directly those information when they come on the site. Prospects and last proposal, the creation of a European portal for posting, and it could give a new mandate to the European Labour Authority. It was also raised in one of the questions. We could create a single European website with all the information on working conditions and the different wages for posted workers. Those information should be submitted by member states, and they could be gathered on a single website and could be translated by the European institutions. We could also contemplate the creation of a real portal for posted work, a European portal that can be used for notifications, previous notifications. On this futuristic note, I would like to conclude my remarks, and of course, I'm all ears for your questions.
Thank you, Marco. And thanks for trying to summarize such a 60-page study in under 15 minutes. Congratulations to you. So, to bounce back on those leads you just mentioned, those proposals, well, we will have three MEPs, and we will start with Leila Shaibi, MEP from La France Insoumise. You have the floor. Leila, over to you. Leila, unfortunately, we are not able to hear you. Marina, do you hear me? Well, actually, I have a couple of devices. That's the reason why I may be facing some issues. Anyhow. Leila. Leila, I think we were able to hear you on the phone. Oh, now you should be able to... Yes? It's okay? Yes, it is. Lovely. Great. You see me, you hear me, everything is fine? Great. Yes, that's a problem with web meetings. We sometimes have some IT glitches. Anyhow. Thank you very much, Marco, for presenting this study. It's crystal clear and it shows the state of play on posted work. And it is very interesting to hear there are some European solutions which are ready to use. And it will be very useful to the European Parliament. It's the French delegation of France Insoumise which asked for this study because with La France Insoumise we think that posted work is at the core of our criticisms vis-à-vis the European Union. The European Union which is serving markets and debilitating workers. We've seen it through the different interventions here today. Posted work is breaking the collective protection mechanisms which have been built through social struggle over the last centuries. So let me answer something we tend to hear quite a lot lately. Something we hear in my country, in France, when we explain with La France Insoumise that we are against this directive on posted work. Some say that being against this is being against the free movement of workers. They say that we would be against the free movement of foreign workers in France. But let's be crystal clear. That's how the far right thinks. And we We are very far from this with La France Insoumise. With La France Insoumise, we are for free movement of workers in the EU, but it must be accompanied with equality of treatment between workers for workers working in the same country on the same workplace. In a nutshell, a Romanian working in Bordeaux, for example, should there have the same working conditions and the same wage, the same rights, and same social protection and social security as French workers. Same protection in case of medical leave or work accident. The thing is that today, this directive on detached workers crystallizes this discrimination vis-à-vis foreign workers. As I said it earlier, we asked for this study and decided to focus on this topic because we were shocked by the increase of posted workers over the last few years. Let me give you French figures. In the noughties, we had some thousands of workers, and today in 2020, we have over 1 million posted workers. 1 million. This is no official figure, obviously, because as we have heard during this webinar, the thing with posted work is that fraud is part of the system. And as a consequence, many posted workers are not declared. Furthermore, there is one cliche which is shared quite a lot. We heard that posted workers would come to France to take French honest workers' work. But when we have a look at the figures, we see that in France, one fifth of French workers are worker are French. We have French posted workers in France who actually work through contracts coming from Luxembourg, and as a consequence, there is fiscal fraud. Luxembourg is obviously very well known for this, and we can see that Luxembourg is also cheating with social security and that Frenchmen are detached in France through Luxembourg. This leads to unfair competition and is no more a tool which should help improving the sharing of services throughout Europe. As we've heard it earlier, posted workers, and I'm thinking about Christian, we've heard at the very beginning of this webinar, there is a new form of exploitation, and as we've heard Christian saying, this is some kind of modern slavery. When someone arrives in a new country and when they do not have the possibility to defend themselves because they don't speak the language, because they don't know the labor code, because they are unarmed, and because they uh, have no working contracts whatsoever, well then they are trapped. And as it has been explained by Marco during the presentation of his study, during the COVID-19 pandemic, we've seen how vulnerable these workers are, and the lockdown has proven it. Workers from the building industry and from the farming sector are fragile because of posted work. And this is very true for France, from the southern part of France. And more often than not, these posted workers are at 30, maybe in a dorm and in very poor conditions, which can lead to clusters of the pandemic. Furthermore, posted work, as it exists today, leads to many issues and tensions between workers on the workplace, although the workplace should be the place where people organize themselves, where they socialize, because on one workplace you can, for example, to talk about the building industry have two workers who have the same experience but different working contracts, different working conditions, and as a consequence they won't this won't lead to cohesion but rather to divisions and tension and competition also, not to mention hostility in between workers. Some say they have struggled for collective labor agreements and then say that migrants arrive and they break everything down and that this is unfair competition. With this system, we only have losers. Workers lose because they are in competition in between each other, and they all would like to be protected and to work in fair conditions. States are losing because of fraud, and in the end, the only winners are the companies, the cheating companies, which exploit workers. With France Insoumise, we observed that it is not possible to reform the state. We have observed that it is not possible to reform the status of posted worker because the ILO and the European Charter of 2013 mm, are not in line with this definition of the EU. These international texts say it is necessary to have an equality of treatment for social security and for labor rights, but it is not possible with posted workers. Furthermore, it is not possible to reform this status because we cannot control it. We've seen it and heard it today with these different examples. The labor inspectors are working in very limited frameworks which do not cooperate. A trade unionist explained to me how labor inspector tried to verify whether or not social welfare had been paid in the origin country, but then this labor inspector was answered that this information was confidential, and as a consequence it is not possible to control anything on posted work. As a consequence, fraud with posted work is a rule, and some may say that if we reform the system, if we give more rights to the workers, it could be possible to solve these issues with the status of posted worker. But the thing is that this status leads to discrimination in between workers, and the revision of the Posted Worker Directive in 2018, and I do not agree with what I have heard, is not applicable. The 1996 directive was not applicable, and today it's still unapplicable. Why? Because because we have vulnerable workers who do not understand the language, who do not know the law, and then we have workers who are unable to organize themselves collectively because there is a lack of structure for trade unions and because of an hostile environment. And the trade union action is paramount to ensure the application of rights. The application of law is only possible if there is a true balance of power. And the thing is that with posted work, it is impossible to organize workers and to have this counter power against the companies. And finally, I would just like to say that at the very beginning, they said that on social security, this directive would help. But today we see it's not the case. When we have a look at the building industry in Slovenia, according to the latest data shared to see how many posted workers we have there, well, we've seen there are more posted workers from Slovenia to elsewhere than workers in the country. How is this possible? Well, because Slovenia sends non-Slovenian workers to other EU countries. Romanian workers, for example, who will receive contracts from Slovenia to work in France. So this means that instead of reinforcing rights, well, rights are confiscated. And Marco Rocca's research has shown everything that is possible, how this EU framework allows for abuse, and this study is essential because it shows us how we could go forward with free movement of workers, but without detached workers, workers living fairly thanks to their work. And thank you, Mr. Marco Rora, for your study, which will be very useful. And finally, La France Insoumise will continue defending free movement of citizens, of workers, who can move throughout Europe and who could continue moving throughout Europe without discrimination and unfair competition through this system. Thank you. Thank you, Leila, for this intervention. Thank you for presenting the French opinion on posted work. And I will now move on to Belgium to hear what's happening in Belgium, hear your opinion. What do you think in Belgium with the PTB about posted work?
Est-ce que vous m'entendez? Ça se passe bien? Oui.
Can you hear me? Yes? Excellent. Well, first of all, thank you for organizing this webinar. Thank you for organizing this very useful exchange. Of course, we listened to the comments of our colleagues, and we are familiar with these experiences. I do think that we have a fundamental problem, and we agree with it. In the EU, when you go to the Court of Justice, the four economic freedoms have the priority. Social rights, then, are not on the same level playing field, let alone having the priority. They are not even on an equal footing with the other economic freedoms of Europe. It should be the opposite, actually. And this is one of the key dimensions of the problem. It's fine to have free movement. Of course, we are not opposed to that, as was said earlier on. But the free movement must be carried out with an equal wage, with equal working conditions, and so on and so forth. It is important when we hear some people speak, they mix everything, and Leila explained that a bit. The free movement of workers and the free movement of services. It's not the same thing. We can have a free movement of workers while repealing the free movement of services if we wanted to. I'm not saying that's what we want, but there is a clear difference to be made. When we talk about social dumping and posting of workers, we talk more about issues related to the free movement of services rather than the free movement of workers. When workers decide to go and work and live in another European country, is integrated in the working market of that country. What about the solutions, the alternatives? I was able to go through the study, to flick through it, and there are some proposals are interesting, some others raise more skepticism, but as workers and trade unionists mentioned earlier on, the issue of control and inspections are key. We can have the best rules in the world. We don't have them, by the way. But if we do not have controls, inspections, it is useless, completely useless. In previous years, we've seen in European countries, because of austerity, because of political choices, the social and work inspection services were weakened. They don't have the resources today to carry out their work, technological, technical, or human resources. They don't have enough means in order to actually control compliance with the current rules. Some rules are existing today and they should be complied with. It's not the case today. I think that the European Labour Authority could play a role, but of course it is no substitute to the social controls at the national level, which is lacking in some member states. Sanctions, no. Controlling, that's fine, but we should sanction as well. In Belgium, an attempt was blocked by the European Commission. It was invalidated. The attempt was to act if fraud was observed, for example, with the form A1, showing that you are registered in another country. If we notice a fraud, we could withdraw the form, and therefore that worker would be under not the law of the origin country, but under the law of the Belgian of Belgium. It was not accepted because, first of all, the procedure provides that you contact the origin country under a loyal collaboration. We have to ask them what happened. You delivered that certification and it's not valid. What happened? Can we agree on something? But since the Altun ruling of the ECJ, progress was made. If a country does not reply to your requests, it is now possible to react unilaterally and to go through the courts in order to impose a fine, a sanction in favor, of course, of the worker. Now, on the posting of workers directive. That directive was approved in 96, and it actually comes in a very difficult situation because there is a free movement of service and it's the Far West. The promise was to improve the situation, but it was not the case actually. It could not prevent social dumping. That's why I'm not in favor of repealing that directive, because I would not like to come back to the previous Far West. It should be improved. The legal basis should be changed. That's important. And of course, it will require a change of treaty. It will not be enough to change the legal basis of the directive. We should also change the standards hierarchy in the treaty, because the Court of Justice will then give priority to the free movement of services rather than to the rights of workers. No, in my opinion, on social dumping, a key point is the wage, social contributions that are paid at the rate of the origin country. And a posting of worker can last for a very long period, as you know. It depends, of course, 18 months in one directive and 24 months in the regulation. That's a contradiction. 24 months in the 833 regulation and 18 months in the new directive. And it's not really logical. It would be nice to harmonize that. But, okay, that's too long. The solutions that are put forward today, were raised already during the webinar, are the following. We could have a previous notification. That previous notification almost exists in some countries. For example, in Belgium, you have a previous notification. It is imposed under the work law. It is called the Limousin Declaration. Before you send a worker to Belgium, be they artists, be they construction workers, have to state in the Limousin form that the workers will be posted. That's a first step. Actually, it's not too bad. It's not perfect. Some sectors are excluded. There are exceptions. But on the whole, it goes in the right direction because today we have problems with the A1 form. It can be submitted after the posting of the worker. It should be submitted before, whenever it is possible, of course. And when you use the term whenever it's possible, that is, of course, leading to some exaggerations. And one of the big challenges on the social security cooperation would be to have previous notification so that the authorities of the hosting country can be aware of the arrival of posted workers. Secondly, and it will not be in the review, I'm afraid, it would be interesting to know which social security regime applies. In my opinion, we should have a free choice of the worker. That's an option. Of course, that leads to problems we mentioned about information, about language, about the familiarity with work law, and we should guarantee that a posted worker at different moments in different countries can have certainty on the applicable legislation, that it does not change every time it changes from one country to another. Again, to use his rights, it could be more complicated when he has to claim for those rights. That's why we need to have a general European system. It could be interesting, I think, but we're not there yet. And it would be very surprising that we get there. There was a question about digitalization earlier on. That's interesting, but let's not forget that that kind of system will take 8 to 10 years to be implemented. So for 8 to 10 years, we need to guarantee the rights of workers. We cannot wait for 8 to 10 years before having an efficient European system. That's not possible. In order to ensure the digital coordination of the notifications, I think that we can make progress while not having that at the moment. Finally, and that raises a lot of questions, a lot of discussions. All of that progress will depend on the different struggles in the different countries. I'm not against the free movement of workers. I'm not against the free movement of services. I think it would be quite odd and unacceptable to say to tile company, an Italian tile company, that you cannot come anymore to work in Belgium. I don't find that logical and normal. That's why in the study, and it is mentioned, we should be very wary indeed of our efforts, of our actions, because everything is complicated for social security. Workers' rights should be protected. The right to move freely can be protected, and we then should have an upward trend improvement of the situation. And I will conclude here because my time is over. I think that the pressure that we will be able to put forward will be important. The current situation entails legal dumping. An example, Belgium. The previous government limited social contributions that have to be paid by employers. But under European regulation, coming in Belgium pay less social contribution. It is a competitive advantage for the foreign companies. Then we will lower contributions for Belgian companies where there is a lot of competition, for example, for the building sector. So we have a social dumping, not at the individual level of the worker, but rather at the legislative level as well. It is weakening the legal structure of the countries. We have solutions at the national and European levels, and what will be key will be the trade union and workers' pressure that we will be able to put. That's it for me. Thank you. Thank you very much, Mark, for your comments. And as we are late, quite late already, I give the floor to Nicola to talk about the prospects from the Danish point of view. You have the floor, Nikolai.
Thank you so much, and thank you for all the good contributions and important proposals. I will try to be very brief because time is running. I think that basically what we're asking for is equal pay for equal work at the same workplace, and that should not be such a big demand, but unfortunately it is. And that's actually why I think it's important to highlight the need for social progress protocol, as Simon from 3F also highlighted, because we need to have this change of treaties in order to secure that workers' rights are put above the rights of companies, because if we do not have that, then we will run into problems time and time again. So this is of course something we should push for, but it's not easy to get. In the current Danish parliament, we have a majority in favor of that. We had the discussion actually today in the employment committee a bit today, but it's not easy to get, and all member states need to agree. So I think a second thing we should aim for is also that we try to push in national parliaments that there's a will to challenge the current rules of the European Union, and to insist that we should not accept that our colleagues are being underpaid and exploited, but we should have the right to demand equal pay and equal conditions at the same workplace. Then, not unsurprisingly, I would like to underline that there's also some important things going on in the European Parliament. I fully support that we need to push for a European social security card, and I really believe that we need to push for a revision of the public procurement, so we are able to exclude companies that do social dumping and discrimination. And then actually I will highlight, just as a final thing, an important vote that we're going to take place next week in the European Parliament, and that is the vote on the agricultural policies. And as you know, there are huge problems in the agricultural sector with discrimination, with exploitation, with wage dumping, and I'm sure that our trade union colleagues are all doing a good job in trying to organize workers and trying to fight this exploitation. I know that 3F in Denmark is doing an excellent job, but we actually have a case that I think that highlights how problematic the situation are. There is a case of a Romanian colleague that allegedly was beaten, he was fired, and he was sent out of the country. Why? Because he did not want to leave his membership of 3F that his boss insisted he should do. And this was not something that happened in a dusty, shady shed somewhere. This was something that happened at the biggest producer of milk in Denmark. So it's just to say that these problems are huge, and what we're basically talking about is that employers are not respecting the right to unionize, and this is of course something that is totally unacceptable. From the left group, in next week we are proposing that farmers and agricultural companies that do not respect collective bargaining, do not respect the right to organize, should not be allowed to have EU funds. I think that is a very concrete thing that we could demand, that could help strengthening workers' organization and workers' rights in the agricultural sector. And I of course hope that other political groups will will support this demand when it's put to the vote next week. So then I will finalize and say thank you for all the good inputs that surely be useful in our upcoming coming work in the coming years. Thank you.
Thank you very much, Nikolai, for your comments. I was not able to have a look at the questions on the chat. Marco, apparently you have to reply to one question. Well, you are familiar with that question, so the floor is yours. No worries. I just replied to one question by written because I know we don't have a lot of time left, and I reply orally to the other one. If you want more information, you have the email on the presentation. You can find me on the internet. Don't hesitate to send me your address and I can reply to your questions. I would like to reply to a question on the legal basis. Why the free provision of service is not the right legal basis? I want to have a two-pronged question. I do not think that my criticism is a reason to cancel the reform of the directive, as requests some government to the ECG, because the directive is applied by the ECG based on that legal basis. All of that does not justify a cancellation of that. Why do I think another legal basis? Because the free provision of service is a right to companies, giving them access to a market. The aim is not to regulate the working conditions that will then be applied to workers who will provide themselves the service. And the free movement of workers, as I mentioned in the study, once the study will be published, you'll have more information, by the way. As I mentioned in the study, the free movement of workers is the legal basis in order to regulate the working conditions. That's why I think it is the right legal basis for that directive. That's it.
Thank you, Marco. There is another question for Mark on the rules on the coordination system for social security. What about the exploitation of for the 883? And then a question on having more than one activity. Would this lead to a new Far West for employers in Europe? So maybe you could answer these two questions before reaching the conclusion, because then we'll have to call it a day, and also, well, respecting the interpreters who are helping us today. Well, I'll give a brief answer. On the exploitation of social prestations, well, you know, we have the trilogues, so negotiations between the European Commission, the European Council, and the European Parliament, and Council of Ministers. You know that we have very different positions. Some say that those cross-border workers can only export their rights for a very short period of time from one country to another. Others within the European Parliament would like to talk about 15 months. We are negotiating, and currently positions haven't changed. We all have our mandates. And, well, we are trying to find a common ground, wait and see. It's a very tricky question for mobile workers. Then on multi-activity, well, we are talking a lot about posted workers now, and I think that it was in Marco Roca's studies, having more than one activity, pluri-activity in Belgium is booming. Pluri-activity is booming in Belgium. but it's not at the same level as posted work yet. And the most important challenge here is that there are fewer rules as for posted work. For posted work, we have all the challenges we have mentioned, the fact that there are problems with controls, etc. But pluriactivity is not even controlled as much as posted work. We have Article 13, but that's about it. As a consequence, yes, it could lead to a far worse, and I have heard many workers and trade unions talking about this. And indeed, some employers may try to circumvent certain rules through pluriactivity. So we will need to keep an eye out on this. Thank you. Thank you very much, Mark. Nikolai, I don't know if you have something to add before I give the floor to Leila to proceed with the conclusion.
No,
Is there something you want to add?
no, please let Leila go ahead.
D'accord, ben, merci.
Very well, thank you. Thank you. Well, Leila, the floor is all yours for the conclusion.
Merci Marina. Ah, on m'entend en écho, désolé.
Merci Marina. Oh, we have a bit of a
Same
lag.
here.
Alors, voilà, c'est bon. Merci Marina.
Thank you. Thank you to all of you. Thank you for this webinar this afternoon. It has been quite some food for thought. We have heard these experiences and now have a better understanding of posted work. We've heard trade unionists, workers, inspectors, MEPs take the floor from everywhere throughout Europe, and we all have the same observations. There is one major challenge with posted work as it exists today. And the examples we have heard are eye-opening. So thank you to these witnesses for talking about their experiences. I wanted to bounce back on everything that had been said to summarize everything. First, we heard Christian and his testimony. Thank you, Christian, for showing us all these challenges posted workers face. Thank you for talking about these 12 to 14 hours shift, the lack of protection, and then these companies who try to play with the system. We've heard that workers are alone facing red tape, and we need to fight for workers' rights, as Christian has said. Thanks to Manuela Paraschivoni, trade unionist from Italy. Thank you for your point of view. It was really eye-opening. You have been following these workers on a daily basis for many years, and you try to find solutions so that justice becomes reality. We have understood it is important for trade unionists to cooperate throughout Europe, and I remember this example of Romanian workers who were working in Sweden with Polish workers working contracts for an Italian company detained by Egyptian. This shows it's completely absurd that this system doesn't work. And thanks to Simon as well from 3F from Denmark. Thank you for your explanation and for explaining how companies can be creative to exploit workers. We have understood that rights exist on paper but are not granted in practice. And indeed, we need same working conditions. We need to improve norms. We need to have one unique social security number and have one wage for one type of work to fight dumping. Thanks to our labor inspector from Portugal, Rui Pereira, as well. Thanks for explaining what you are seeing on a daily basis and the lack of balance between reality and theory. Thank you, Marco Roca, for your study and for presenting this study today. Thank you for these political and legal solutions you put forward. Thank you for taking into account the stakes and the tensions as well. Tensions and stakes which have been mentioned throughout this webinar. Thanks to my colleagues, Mark Botenga and Nikolai Willumsen as well. Thank you. This topic is very dear to us within the European Parliament. I have the opportunity to be part of the Employment Commission within the European Parliament with Mark and Nikolai, and we are fighting for fair working conditions for all the workers within Europe, and we'll continue debating about this and continue the struggle together, hand in hand, to reach this target, to have fair and decent working conditions for all. Thanks to all, and thanks to the interpreters as well. Thanks to the GUE for organizing this conference, and thanks to Simone Yosser and to you, Marina Mesure, for organizing this conference and for moderating this webinar.
Merci à tous.
Thank you, Leila. Thank you to all of you. Do not hesitate sharing your questions or remarks. We remain at your disposal. You should have access to our details in the chat. Thanks to all of you, and see you very soon to continue exchanging. Goodbye. The interpreters wish you a lovely afternoon.